Okay, so again, please put yourselves on mute. Welcome to everybody. Money considerations when working with cancer. Um, trying to make it work for everybody. So thank you. And now introductions.
Thank you. Welcome, everyone. We have got a great group of presenters tonight on our panel. First, I'd like to introduce Megan Hendricks. She is an attorney and the founder of Sage Legal Group. She focuses her practice on estate planning and estate administration. Her goal is to ensure her clients' wishes are followed in the most efficient manner possible to ease the burden on the family. She also touches on Medicaid asset protection strategies and helps her clients with adult guardianship proceedings. Next, we have Jay Neary. Jay is a certified financial planner and financial advisor with the Wealth Enhancement Group. Jay is passionate about helping individuals with a change in health, such as a cancer diagnosis, navigate personal finances. And lastly, we have Chris McCardle. Chris is a Wisconsin licensed insurance broker with MKE Benefits. He leads the team that serves as advisors for health-related insurance needs for clients throughout the state of Wisconsin. So Chris, I'm going to pass the mic to you and we can get started. Thank you.
One quick note for folks.
That's fine. All right. Hello, everyone. Hope you can see my screen now. You got a thumbs up? All right. Excellent. As introduced, I help people figure out insurance. Ultimately, my firm is a brokerage. We help people buy the insurance plans they need, but sometimes part of that is consultation and giving people advice. And so tonight, that's what we're doing. We're not selling or buying anything tonight, just helping share some knowledge for those who may need it now or in the future. So the topic is what happens when employer-provided health insurance ends. So we are going to talk about that and what the next steps are. And we'll start with talking about loss of eligibility. So when somebody is working and they are covered under their group plan, they typically have to be working 30 or more hours per week on a regular basis to be considered full-time. So someone that, works 4 days at 8 hours, some may not consider that full-time, but in the state of Wisconsin, that is considered to be full-time, and that person would expect to be able to stay on that group plan. But if somebody is no longer working 30 or more hours per week on a regular basis, they will ultimately lose access to their group plan. And so that could be someone who can only go part-time status, or someone who simply misses work, or someone who can't work anymore, or decides not to work anymore. They're going to lose that full-time status. They're going to lose that insurance. Now, when insurance ends, coverage may end the day their status changes, but most likely it's the end of the month. So if someone today went in and told their boss or their supervisor and say, listen, I can only work 20 hours a week from here on out, they very likely would be carried through the end of this month, but then coverage would end after December 31st. So January 1st would be their first day without coverage. Now, some employers may keep people on the active group plan for a length of time. This is particularly true if they're on disability. So if someone is not working and they are deemed to be disabled and they're on the group short-term or long-term disability plan, they may be eligible to stay on that plan longer. Their employment may not terminate while they're on that disability plan, but eventually that person is going to be told, I'm sorry, we need to end your coverage in order to comply with the insurance rules about how much people are working and their active employee status. Now, if somebody loses eligibility, whether it is because they go to part-time, they physically cannot work anymore, or they choose to not work anymore. They choose to stay home, take care of themselves. Whatever that loss of eligibility is, that is a qualifying event to join the coverage that perhaps is carried by a spouse or a partner. So if we have somebody who is working and both, if they're married and both spouses are on one plan and the person who's working and carrying the coverage stops or loses eligibility, if that second spouse has access at their employer, they could both hop over there. Or if they each carry their own coverage and one person loses it, they could jump over to the plan of the other. And that is a qualifying event. That's a special enrollment period. And that could happen at any point during the year. That doesn't have to occur during open enrollment when all sorts of other voluntary changes could be happening. So when somebody loses coverage, what happens next? So the first question that a lot of people ask is, well, I was just at the doctor, I was just at the hospital a week before coverage ended. What happens now? Well, that claim, if it is incurred while still covered, if the date of service, if it actually happened while you were still covered, that claim will still be submitted and paid, even if it isn't processed until after the date of termination. So someone who goes to the doctor today and then they leave work at the end of this month, there's a good chance that claim will not be processed and paid by December 31st. That may happen in January, even February, but that's fine. As long as that claim happened while they were still covered, while they were still deemed to be an eligible employee, that is still a valid claim and it will still be processed and paid. Now, from the group side, that individual will almost always be offered COBRA or something called state continuation. State continuation is basically a mini COBRA for smaller companies, companies with fewer than 20 total employees. Almost always someone will be eligible to continue their coverage, allowing them to stay on that group plan. And COBRA is not a separate plan. It's not a new program. It's not different coverage. It's exactly the same coverage that someone had the day before they lost eligibility. And really the biggest difference in terms of the coverage is that the individual is responsible for 100% of that premium. While employed, someone's employer might be covering 50, 70, 80, 90% of the premium. But once they're no longer actively employed and they're on COBRA, that individual will be responsible for paying 100% of that premium. Now, some things to remember, if we're doing this in the middle of the year, deductibles and out-of-pocket maximums do not reset. So someone who has surgery in September and then coverage ends at the end of November, they do not need to start over on December 1st, presuming that that plan has an annual deductible. So any deductibles out-of-pockets met earlier in that year will continue. So someone's not going to be punished by having to start over with a whole new deductible and out-of-pocket maximum. And then both COBRA and continuation can typically go for up to 18 months. There are some special exceptions, but typically it is an 18-month duration that one can keep their continuation coverage. Now, an alternative to COBRA or continuation is the marketplace. Now, the marketplace, the ACA, the Affordable Care Act, Obamacare, the federal exchange, these are all the same things. They're all just different names for a federal program that helps facilitate the purchase of individual coverage. And so that individual, when they get their COBRA offer, they could look at that and then they could look at the marketplace and they say, which is best for me? And if that individual stays on the group plan, they could move to the marketplace on January 1 or when COBRA ends. So there's a couple of special enrollment opportunities to get into the marketplace. When they first lose eligibility, the next January 1st, and if they stay on COBRA, the second January 1st, and then when COBRA ultimately ends. all of those are different opportunities to get in the marketplace. The marketplace does not ask medical questions. It does not have pre-existing condition limitations. There are no penalties for someone who has a diagnosed condition. Just like COBRA or state continuation, you have full coverage day one. The only difference is that if it's mid-year, that individual will be starting over with a new deductible and out-of-pocket maximum. And I mentioned this briefly, bullet 3, marketplace plans, it's not a government-run program. I'm sorry, it's not a government-run insurance program, but it is a government entity that facilitates the purchase of coverage. So someone who goes to the marketplace, they might be looking at plans offered by Anthem Blue Cross and United Healthcare and smaller local operations like Chorus Community Health or Network Health Plan or Quartz. These are the same plans that one could buy by going directly to the insurance company, but by going through the marketplace, that individual may help or may get help paying their premiums based on their income, their zip code, their family status. There is not a one-size-fits-all solution. There's not a one-size-fits-all answer to which is a better way to go, which is why we have to talk to people on a one-on-one basis and find out what's best for their particular situation. Now, one thing to consider, which I mentioned is not part of the COBRA solution. If somebody moves from a group plan to an individual plan mid-year, even if that premium is lower, it may not be the right solution. So someone who met their out-of-pocket maximum earlier in the year, and they need new coverage starting October 1st. So they have 3 months left, and they're told that their COBRA is $1,000 a month. Holy cow, that's a lot. But if they have 100% coverage for everything for the remainder of the year, and that costs $3,000, all right, we know what option A would be. Option B, going to the marketplace, they may be able to get a plan for $500 a month. But if they have to satisfy a new deductible and out of pocket, and that might be $7,000, $8,000, $9,000, depending on the plan they pick, and they have ongoing care, all of a sudden that $3,000 premium looks a whole plus 0 claims looks a whole lot better than $1,500 in premium plus 8,000 in claims. So again, these are one-by-one decisions that really need attention based on the individual situation, based on what the employer is offering, based on what those costs are, and based on what their situation is at home to determine what the marketplace has to offer. A few other things to consider. When we're talking about the marketplace, those plans are age-rated and they are income-based. And so someone who is either older or a higher income, it is more likely that COBRA would be a better solution for that person. When we talk about COBRA, most of the time, we are looking at we are looking at premiums that are not age-rated, and they don't take family size into account. We talk about tiered rates. So many of us at our place of employment, there's a single rate, there's a single plus spouse, there's a single plus children, and a single plus spouse and children. And whether someone is 25 years old or 63 years old, they're going to get the same rates at work. And so when those people look at a marketplace plan, that 23-year-old is going to have a very different rate than a 63-year-old. In fact, there's a 3-to-1 ratio on the marketplace between the lowest and the highest rates. So someone who's 60 years old and considering an age-rated plan versus a 25-year-old, but they both have the same COBRA premium, well, that older individual is probably more likely to end up with the COBRA plan versus the marketplace plan. Second thing to think about, disability. If somebody is unable to work and they are deemed to be disabled by Social Security, they may start receiving Social Security disability payments. And one thing that the federal government does is that once somebody starts getting those payments, if they go 24 months, and it's 24 months from date of disability, so someone may get a catch-up of a year and a half worth of disability payments by the time the government actually deems that person to be disabled. But 24 months from the date of disability, that person will automatically be enrolled in Medicare. Medicare, both Parts A and Part B. And at that point, we would be talking to somebody about most likely getting into an Advantage plan. And I don't want to go too far down the Medicare rabbit hole, but there are Advantage plans and there are supplement plans. Someone who ends up on Medicare before age 65, it is because they are disabled and or has a very, very serious illness. And those premiums are quite high on the supplement plan. But kind of like Cobra, Advantage plans are not age rated. So someone, whether they're buying a plan at 65 or before then, the Advantage premiums are the same, the benefits are the same. And so often for someone ends up on Medicare before age 65, it makes sense to go to an Advantage plan until they turn 65. And then they get what in only the government could come up with this, a second initial eligibility period. So when they get their, when they reach 65, that person can switch from an Advantage plan to a supplement plan without answering any medical questions. And again, without any pre-existing condition limitations, exclusions, or rate impact. So third bullet, we talk about Medicare, Marketplace, Cobra, all of these, it's important to remember, will not ask medical questions, will not exclude conditions, will not prevent somebody from getting the care they need, and will not impose a surcharge for someone who does have extra needs, as long as we're doing things at the right time in the right order. And so that brings me to number 4, which may be one of the more important things. If possible, talk to a professional, talk to somebody who does this 2 months or so, 3 months, that's wonderful. I have people that call me and they say, hey, this is going to be happening. I might be calling too early. And I would much, much, much rather have somebody call me a month or two too early than a month or two late. And it doesn't need to be me, folks. There are lots of folks who do what I do. There are, some other really good agents in town. If you have a relationship with somebody, fantastic. Remember that working with someone who does what I do doesn't cost anything. The state of Wisconsin, the insurance companies and the Office of the Commissioner of Insurance want people to seek out expert assistance. They want people to get help. They don't want people making silly mistakes that could cause problems for the rest of their lives. So unlike many other aspects, of your life, where you may choose to change your own oil or bake your own desserts for Christmas or whatever because you like it or because you want to save money. No one likes doing insurance, and no one can save money by doing it on their own. So whether it's me or someone else who does what I do, please seek out assistance to make sure that you're in the best possible position when you have these transitions. That is what I have. Thank you, folks. Again, Chris McCardle, I'm with MKE Benefits, and I appreciate the opportunity to share some knowledge, and hopefully people learned a little bit tonight. Afterwards, gotten to be very good at giving free advice to friends. I tell people all the time, please don't wait to call me until you think it's a sales opportunity. If you have a question, if you just need advice, if you need to clarify something that you saw online, I'm happy to hear from you, and happy to share a little bit of knowledge. I can spend 5 minutes returning an email that might take 2 hours to try and research on Google, and I'm happy to do so. So thank you, and I will turn it over.
Thank you. And we are going to go to Jay.
All right. I just have to say, Chris, I'm glad you like insurance though, because we want you. So. All right. Just pulling up the screen, everyone. So as I'm pulling up the screen, I am a certified financial planner. I'm in the Milwaukee area, and I've been in the industry about 11 years now. And actually, several of those years, I've worked with individuals with a cancer diagnosis, and it's something I'm really, really passionate about. And I've learned a lot, and I'm still learning and constantly learning. So I'm excited to just share some of the things I have learned in my work, and I hope it can help you. But let's get started. So, show of hands, some of you maybe feel like this person right here when it comes to your cancer diagnosis and finances, or even just your cancer diagnosis in general. And there's a lot of jargon in the industry. There's a lot of terminology maybe you're not familiar with. When you make financial decisions in one area, you can impact financial decisions in another area. So there's a lot of just kind of intertwined parts when it comes to finances. And so you might be wondering just where to start when it comes to finances and cancer. But I would argue probably one of the most important things you can do is to just have a sense of what your financial picture looks like. And for those of you that haven't done that, just have a sense of what you have saved, the debts that you have, those debts, what sort of interest rates do those debts have? What sort of, income and expenses are coming in? So just your cash flow on a month-to-month basis. Just have that understanding of your financial situation, because if you don't have that, it's really hard to make informed decisions because you don't have that reference point, you don't have that framework to work off of. So I would argue, before you really make important, big financial decisions, start there. I also encourage you to have a to-do list. I think this is really, really important, and have some action items. And you might find, with a diagnosis, with finances, and all the different aspects of finances that you want to try to knock out, you might find that to-do list is pretty long, and that's okay. But if you're feeling overwhelmed and to the point where it's hard to kind of get started with that to-do list, I encourage you to break it up into little pieces. Break it up into 1 to 3 pieces at a time and knock those out. Build momentum. But I encourage you to go easy on yourself as you kind of start this journey with finances, and try to make it as simple as possible. And then another thing I think you should do is ask for help. And it doesn't have to be from me or anything like that, but ask for help. It could be a family member, it could be a friend, it could be someone at Gilda's Club. Actually, just a couple weeks ago, I met with a cancer patient, and it was in the hospital, and she was asking me really, really good questions. She really knew her stuff. She was really advocating for herself. And what I thought was really, really cool was she had her siblings, 2 siblings, in the room with her. And her siblings were taking notes, and they had their computers, they were typing up notes, they were helping to ask questions. And I think that's great. So I think if you can get that help, if you can get that support, especially with everything going on, don't hesitate to take someone up on that. Okay, so when we think of the cost of cancer, and many of you are probably here today because you're already aware of the cost of cancer. But when you think of the cost of cancer, it goes beyond just the medical cost of cancer. And I don't just say just, I mean, that's a big piece. But what I would argue is that cost of cancer is even broader. So much so that it's actually recognized as toxic. You do a quick search of medical literature, and you'll find financial toxicity describes just the financial impact of a cancer diagnosis. So you think about things like traveling for treatment. If you're getting treatment out of state, and maybe it's airfare, maybe it's lodging, maybe it's getting more help at home while you're gone, or childcare, Or maybe you're in a situation where you've lost access to employer benefits. You've separated from your employer. You no longer have employment income. That quickly just creates just a broadening impact, financial impact with a diagnosis. So if you're feeling just overwhelmed with that cost, know that it's not alone, and know that that's very normal, unfortunately. So, like I said, I'm constantly learning, and over the years, I've had the privilege to work with a number of individuals with cancer, and I'll tell you this, each of their situations is unique. Your situation is going to be unique to you. But what I wanted to do tonight is to kind of just cherry pick some of the common themes that I have seen in my work with individuals with cancer. And by no means, you're going to hear a lot of content tonight. By no means are you going to walk away an expert in finances. And I don't think that's the goal tonight. What I hope happens is it just gets you thinking about things that maybe you haven't thought about before. Maybe it just gets you thinking kind of creatively about your own situation, and recognizing that there are different resources out there that maybe you haven't thought about. All right, I want to start with retirement savings, and I'm not talking about saving for retirement, which is quite frankly what a lot of people think when they hear certified financial planner. That's very much a big part of our profession. But I'm talking about a situation where, what if there's a cancer diagnosis in your 30s or 40s or early 50s? And let's say you've used up what you have saved in the bank. So you've used up your financial resources, and you're now looking at your retirement accounts, which you had previously been saving for the future, a ways down the road. And all of a sudden, those retirement accounts, it's no longer a future kind of bucket of money. You're in a situation where now that needs to be an important financial lifeline for you today. And I bring this up because the IRS defines retirement as 59 and a half. Why they have 59 and a half and the half, I have actually no idea. But that is the kind of magic retirement age, which means that's the point in time where you can take a distribution from your retirement accounts and you no longer have any penalties. And those penalties generally amount to another 10% tax on top of any federal and state taxes. So going back to the example of a cancer diagnosis in your 30s, 40s, 50s, that can quickly become significant from a financial standpoint when you're taking early distributions. So I want to break it down a little further. I would like to first talk about employer retirement plans, and then I want to talk about individual retirement accounts as well. And I'll tell you this, every employer retirement plan is different. So everyone's different. There's going to be unique rules that govern your employer retirement plan. And I encourage you, before you start anything, start by requesting your plan's summary plan description, or SPD, as we sometimes refer to it. But that's going to be the rule book for your employer retirement plan. You'll look through that rule book, and if you're in a situation where you're looking to take early distributions from your employer plan, and just to clarify even further, when I say employer plan, I'm referring to 401k, like a 403b would be another example. These are employer retirement plans that I'm referring to. But generally speaking, when you look through the rule book for these employer plans, you're going to see three main ways to gain access to the money. And one of those ways is going to be what's called a retirement plan loan. And a retirement plan loan is actually exactly as it sounds. It's you're loaning yourself money from your employer retirement plan. And you can actually borrow the greater of $10,000 or 50% of your vested balance. So depending on what your balance is, you could potentially pull out up to $50,000. That's the maximum you could pull out. If you're married and your spouse has an employer retirement plan, they could also pull out a loan as well. And a retirement plan loan is attractive because it's not taxable and it's not penalized. So that's huge, rather than subjecting yourself to taxes and penalties. But there is a trade-off, and the trade-off is missed market performance. So let's say we have a year where the market's up 15%. Let's say you pull out $50,000. Well, that $50,000 did not participate in that market growth of 15%. I also caution you, if you leave your employer and if you have an outstanding loan, that loan have to be repaid at that point in time. And if it's not, then at that point, it can be deemed a distribution subject to taxes and potentially penalties as well. Another provision in order to gain access to money within an employer plan that you see in summary plan descriptions. Another way to do it would be with what's called a hardship distribution. And this is where you've demonstrated to the plan administrator that you have a heavy and immediate financial need. So like a cancer diagnosis, and you're taking an amount out necessary to satisfy that need. You self-certify. Now you're going to pay taxes, and you're likely going to pay penalties too, unless you meet an exception to that 10% penalty. Otherwise, really the other way to gain access to money in the plan is if you were to leave your employer or if you were to become disabled. That's a situation now where you can pull money out of the 401k. You're no longer working there. But again, you're going to be potentially subject to not only taxes, but also that 10% penalty. So I mentioned that 10% penalty a lot. And I want to share with you some of the exceptions to that 10% penalty. And this is not an complete exhaustive list. If you want a complete list, go to irs.gov. But I tried to cherry pick the ones here that I felt were just most relevant for our conversation today. So, unreimbursed medical expenses over and above 7.5% of your adjusted gross income. That amount is not subject to penalty. Subject to taxes, but no penalty. Total and permanent disability. A terminal illness, which is expected life expectancy of 84 months, not subject to penalty. Taxes, but no penalty. If you leave your employer, you can set up what's called 72T payments. Now, I'm not going to get into the details here, but know that it's a way to structure distributions where you take a set schedule of distributions over your life, and it's a way to pull money out of the plan early and avoid that 10% penalty. I definitely encourage you to work with an accountant if that's a route you end up going. Some plans allow you to take an early distribution if you retire after age 50, or even as early as 50 if you're a public safety employee. And actually, I had a client that did this, and the client, it wasn't the client who had the cancer diagnosis, it was his spouse. His wife had a more advanced cancer diagnosis. She retired early. He also wanted to retire early, and he was about probably 56. And he looked at his plan, summary plan description, and his plan allowed for this early distribution. It had that provision in the summary plan description. Now, the key catch with that rule is that the money has to stay in the 401k plan to keep that exception to the 10% penalty. As soon as you roll that money out of a 401k and into something like an IRA, you lose that exception. So in his case, he kept the money in the 401k, and that funded their early retirement while his wife underwent treatment. If you have a 457 or non-qualified plan, these are non-qualified plans. Generally, you're not going to look at that. You're not going to see that 10% penalty. Couple other exceptions: qualified birth and adoption, qualified domestic relations order as a result of a divorce. But otherwise, if you don't meet one of these exceptions and it's not a loan, generally speaking, you're looking at taxes and a 10% penalty. Now, an IRA is a bit more flexible. This is a retirement account that you have set up on your end. It's not through an employer. So you could have an IRA, you could have a Roth IRA. Because this is an account that you set up, you have complete control over how you take that money out and when you take that money out. You could take that money out tomorrow if you wanted to. But again, whether or not you're going to be subject to penalties in addition to taxes depends on whether or not you meet exceptions. And you'll see that for IRAs, the exceptions are a little bit different, but there's quite a bit of consistency. A couple of the unique ones: health insurance premiums while unemployed, qualified first-time home buyer, higher education. And then I want to mention the Roth IRA as well. So for those of you that might not know, a Roth IRA is an after-tax account, meaning it's in a retirement account that you set up and you contribute to it with money that's already been taxed. That money goes into the Roth IRA. It grows tax-free until retirement. But let's say with a cancer diagnosis, you're looking at that as a resource right now. Well, one of the unique rules with the Roth IRA is that you can pull out your contributions that you've put into a Roth IRA without tax, without penalty. And you can leave, if you want, the earnings on that Roth IRA within the Roth IRA. So that's potentially an account there that is relatively low-hanging fruit as far as minimal financial repercussions outside of dipping into your retirement fund. So something to consider there as well. Otherwise, if you don't meet an exception here, you're looking at taxes and potentially a 10% penalty. Now, I mentioned, the E got cut off there, but I mentioned, these different accounts, and, we talked about pre-tax and we've talked about the Roth. And I mentioned, when we first started here together, how important it is to just have a sense of your financial picture. And really, this is why, because as you gather that information, you might find that you have a few different types of accounts. You might have accounts that are tax deferred or subject to ordinary income tax rates, your ordinary, federal income tax rates. Those would be like IRAs, 401ks, a 403b. You might have a brokerage account, which is an after-tax account. It's not a retirement account. It's not tax sheltered or anything like that. You pay taxes on it as you realize gains and you realize income. If you sell something that you hold for more than a year, though, you're looking at lower long-term capital gains rates. So that's attractive. And then you might also have a Roth, like a Roth 401k or Roth 403b or Roth IRA. These are tax-free if it's a qualified distribution. But what you'll find is you might have these different types of accounts that are taxed in different ways. And it's important, again, to have that framework in mind, because your tax situation is likely going to change year over year. And your distribution, your optimal distribution strategy likely will change year over year as well. So you want to be mindful of that and determine what makes the most sense as far as distributing money from your investments with any given year. And when you're thinking about the appropriate account to pull from for making ends meet from your investments, when you're doing that, I also encourage you to think about the risk that you're taking in that account. And to give you an example, going back to that example where I had the client who retired early, around 56, his money was in the 401k, it was funding his early retirement. In that case, that account was invested very, very conservatively, because that was their early retirement. They didn't want anything to happen to that account as much as possible. They wanted to protect that account from volatility. They were okay taking a little bit more risk in some of their other accounts, but that one they did not want to. So, it's helpful to think about, the different types of accounts that you have and when you're going to access that money, and then think about the risk you're taking in those accounts as well. Okay. Shifting gears, I want to talk briefly about group benefits. I think this is an important financial planning consideration with the cancer diagnosis. And I want to just highlight a couple of key things, because you might go through, for example, open enrollment. We just kind of, left that season, but if you have a life change where you're looking at re-enrolling in, looking at group benefits, or your spouse changes a job and you're looking at enrolling in new benefits or something like that, just be aware of some of these key features with group benefits. So pointing out just a couple things, group life insurance, I just encourage you with a cancer diagnosis to take advantage of any life insurance you can get that is guaranteed issue. And what you'll find is with these group life policies, they offer generally a certain threshold, up to a certain threshold, guaranteed issue, meaning no medical underwriting. So take advantage of that with your own employer. And if you're married and if your spouse has benefits and you have the opportunity to also get some life insurance through your spouse's employer, try to capture any guaranteed issue life insurance on that end as well. For group disability, Chris kind of alluded to some of this. I'm not going to go into the details here, but the big thing is if you're in a situation where you're looking to apply for disability, like long-term disability, I just encourage you to review your policy, review how it interacts with other benefits. Some might be surprised to know that actually their group disability policies interact with other disability benefits like Social Security disability. And the two benefits can actually offset one another, and that can sometimes lead to surprises. So again, be proactive, avoid surprises. If you have a critical illness policy, a cancer diagnosis could be a triggering event where you could capture some of those benefits. Just review your group benefits for any critical illness coverage if you have any existing coverage in place. Health insurance, I know Chris touched on the health insurance. I just echo some of the things he said. Just review your situation today, review what makes the most sense for you as far as a health savings, a health insurance coverage. You might have a lower premium, you might have a lower premium plan, but a higher deductible, higher out of pocket, and that might not be the right fit for you. You might want to look at a plan that has higher premiums, lower out of pockets. So work with a health insurance agent to understand your situation, and make sure you're dialing in on a plan that makes the most sense given your situation today with your diagnosis. And then I also encourage you to review your retirement plan. And I want to just mention here in terms of contributions that are being made to retirement plans. So if you're going through with a cancer diagnosis, if you find that your cash flow is getting stretched, an easy way to add to your cash flow is you certainly could consider reducing retirement plan contributions. Now, I'm not saying saving for retirement is not a good thing. That's not at all what I'm saying. It's an important thing to save for, and I encourage you, if you can, try to get your employer match at a minimum. But you really do have to prioritize meeting those immediate needs if you're in a situation where cash flow is getting tight. So don't hesitate to make changes there. You can always go back and you can revise those changes in the future, but another way to just improve cash flow. And I'll wrap up with life insurance. And this is actually a strategy that I've used with a few clients. And this is something that would come up with a more advanced cancer diagnosis. And it's a situation where if you have a life insurance policy, you can review the riders of those policies. And within those policies, you might find that there's a rider that offers accelerated or living benefits. And this is a benefit that pays out a part of the death benefit while you are living, a portion of it, and then the residual amount goes to the beneficiary at passing. So to illustrate that, we have a $500,000 life insurance death benefit here. The accelerated benefit is $350,000, which in this case, let's just say this person was approved and eligible. And sorry for my barking dog, you can just ignore him as much as possible. But in this case, they have the $350,000 coming in, and that's a really, really important resource. If you have a group life insurance policy, you may also have accelerated living benefits there as well. I actually had a few clients that had more advanced cancer diagnosis and they were looking to retire early, and they had some group life insurance. And I encouraged them before they retire, see if they qualify for an accelerated or living benefit, because that life insurance policy was going to be dropping away anyway. And actually in those cases, they were approved for this accelerated living benefit. They were able to pull out that benefit while, while they're still living, and to help fund their early retirement. So just be proactive, review all the resources that you have. And that's why I think it's so important to have that big picture, so you can really take a step-by-step look at your finances. So with that, I will turn it over to Megan.
Thanks, Jay. All right, so hi everyone, I'm Megan Hendricks, and I'll be talking about estate planning tonight. So let me just get my screen going and then I can get started. All right. Okay, so estate planning is an important step. It's really, it's important for everyone, but I think particularly when someone gets a cancer diagnosis, this is often on their minds. And so hopefully tonight I can just kind of review some important information, shed some light on estate planning and the different tools that can be used. So a lot of goals with estate planning. I would say, I just tried to highlight some of the goals here. So obviously designating beneficiaries of the estate. Often, at least my goal with clients is to avoid probate. I know with minor children, a lot of parents are worried about designating guardians for minor children. And then if there's young children or special needs children, especially making sure that there's trust set up for them. Reducing estate taxes, if any. We'll talk about what those thresholds are. And then also part of estate planning, which I think people tend to overlook, is planning for incapacity and emergencies. So a lot of people think about what happens after they pass, but we also need to deal with what happens if you're unable to make decisions and need someone to step in and make decisions for you. So before we get into estate plan, I just want to talk about what happens if you don't have an estate plan. So there are some orders of priorities. And a lot of times people will ask me the question, if I don't have anything, if I don't have a will and I don't have a trust, do my kids become ward of the estate, or do I, does my money go to unclaimed property? And the answer is no. So thankfully, it's not as dire of a situation as those examples, but still something that we want to plan for. So the first thing, if I have a estate administration case that I'm helping on, and client comes to me and we kind of need to see what's going to happen with this estate, one of the first things that I'm going to look at is the title of property, title of assets, because title will often control. That's kind of the first priority. So joint tenancy or survivorship marital property is an example of things that I see frequently with married couples, right? So you might have a joint bank account with your spouse. That joint bank account is going to automatically become your spouse's, or whoever the joint owner on that account is, could be a child. It's going to automatically become that person's bank account. Survivorship marital property is often how spouses own real estate. So if both spouses' names are on the property and the property was purchased while well married, it's presumed survivorship marital property, which means that the deed automatically transfers to the surviving spouse without probate. So title is a big important tool that we use, and without an estate plan can still help avoid probate. Beneficiary designations are the next thing that we look at. So then I want to see, okay, if I have a individually owned asset, my next question is there a beneficiary designation on that account or on that asset? Beneficiary designations supersede wills and trusts. And so, that designation is essentially a contract that you made with the financial institution saying, when I pass, this financial institution has to pay that beneficiary. So that's the next layer of priority. And then from there, we look to see, okay, is there a will or a trust or, some document that's going to discuss the designation of assets upon death? And then if not, so then we get to the laws of intestacy. And what that means is it's the state's way of deciding who your heirs are. So if you haven't done that in a will or a trust, then the state takes over and says, okay, we're going to say that these are your heirs, and this is who your money is going to go to. So the downside of not having an estate plan would be that, the law could determine your beneficiaries. So that's where the law of intestacy comes into play. The court could decide the guardian of a child. So you typically, if there is a family member able and willing to take on that role, it would be a family member as a preference, but the court would ultimately decide who that family member would be. And then another downside would be that if assets are going to a child and they're currently minor children or young children, that goes into a custodian or guardian account, and then the child would receive assets at 18 or 21, depending upon the type of assets and the amount. So these are the laws of intestacy, and there's a chart here. It's probably hard to see, but in your slides, you can kind of blow that up a little bit more. So just to kind of summarize a little bit, if a person is unmarried and has no children, then their first heirs would be their parents. If their parents are deceased, then it goes to siblings. If they don't have siblings, then grandparents. And then if it's a person who's married with children, children of that spouse, then their heir would be their spouse. If their spouse has passed, then it's their children. And if their children has passed, then it's their grandchildren. If a person is married but has children from a previous relationship, then it's, their heirs are a combination of their spouse and their children. And that's where we look at, okay, the spouse has their share of marital property, and then is the heir to 50% of the remaining assets, and then the children receive the other 50% of remaining assets. So this is what the law says if you haven't specified in a will or a trust. So estate planning, it's not just one document. There's we kind of have a package or a wide variety of documents that we want to make sure are included in your overall estate plan. And we're going to touch on all of these documents tonight. So first of all is the will, and that's what most clients, come to me and say, I need help creating a will, because that's a word that most people are familiar with. But I think where the misconception lies is that a will actually is a probate document. So often people think that a will avoids probate. It means that your estate doesn't go through probate, but that's actually not true. What a will does is it tells the court who your beneficiaries are instead of the law telling the court who your beneficiaries are. So the benefits of a will is that it, does allow you to designate your beneficiaries. It is the only document that you can use to designate guardians of minor children. And it also designates your personal representative, which is also known as the executor. You can also waive bond for the executor. So bond would typically be like an insurance that the court would order if, just in case your PR or your executor ran off with your money, the bond would be the insurance that would repay the estate. Most of the times we waive that if it's a trusted family member. But I would say overall, my opinion is that a will is not the best tool for most people because of probate. Probate is a court process that administers estates. And anytime we get the court involved, there's going to be more fees, more work, and more time spent. So when I'm working with clients on estate planning, I'm looking at how can we set up the estate to avoid probate. And that's where a revocable trust comes into play. So a revocable trust is a legal entity. And because it's a legal entity, it can own assets. And that's how we avoid probate, is we have your assets being distributed to your trust upon death, or perhaps by retitling assets during lifetime. And then the trustee that you designate to succeed you is able to manage those assets as trustee of this legal entity. So that's how it avoids probate. In reality, from the perspective of the client, the trust is a document. So similar to the will being a document that tells the court how to administer the estate, a trust is a document that tells the trustee how to distribute the assets after death. But the benefit obviously being no probate. So the trustee has a fiduciary duty to administer the trust as you've directed in the trust document. So they can't deviate. They can't make their own decisions about who should get assets. And having a fiduciary duty means that if they did run off with the money, or they did something that was, in violation or not as the trust instructed, the beneficiaries could sue the trustee for breach of fiduciary duty. So there's not the court oversight that the will has, but there still are some protections in place to make sure that the trustee does what they're supposed to do. The trust is going to designate your beneficiaries just like a will does. The trust is also more flexible because it can hold assets. So whereas in a probate, assets going to minor children have to go, directly to a custodian account that then that child gets access to right away at 18 or 21. What we can do in a trust is we can actually say that the assets will be held until the child reaches a certain age, and that's an age that you can set. So I'll oftentimes have clients who will say, okay, let's hold assets in trust for my children until they're 30. And so the trustee has control of those funds for the children, can use the funds for health, education, maintenance, and support, but the child themselves doesn't get control of that money until they're older. And this is also something that can be utilized for a special needs child, which, that trust is typically held in trust for the child's lifetime. And then I also have clients who maybe they just, their kids are adults, but they just don't manage money well. There might be drug or alcohol issues. And so then we're looking at holding the trust open for a longer period of time or possibly lifetime. Another huge benefit of revocable trusts is that it's private. So probates are public record. You can CCAP someone's estate and see a little bit of detail online. Or, if someone's really nosy, they could go to court and request copies of documents. Whereas with a revocable trust, because it's private, no one except for the beneficiaries are entitled to receive information. So no one can, kind of snoop around when they're not part of the trust, not a beneficiary of the trust. There's some tax planning components to a revocable trust. We'll talk about those estate tax exemptions. It's not as applicable to most people with such high exemptions that we have. And then trusts are also good for blended families. So I see clients who, maybe this is a second marriage for both of them. They have children from previous relationships, and they're wanting to make sure that they can provide for their spouse and their children, and we're able to, utilize some flexibility within the trust to do that. Okay, so estate tax sounds scary, but doesn't apply to a lot of people. So Wisconsin does not have estate tax. That was eliminated in 2008. So the only thing that you have to think about is federal estate tax. And our exemption is so high that we're really talking about extremely wealthy individuals that their estate would pay tax. Since we're so close to 2025, I just went with 2025 exemption amount, which will be 13.99 million per person. So that means that if someone is married, you can double that exemption. And that means the estate can pass, close to 28 million without paying any estate tax. Right now, the law is set to expire at the end of 2025. And so January 1st of 2026, if they don't extend it, then our limits could scale back to 2017 limits adjusted for inflation. So we kind of anticipate 7.5 million per person could be the exemption amount if it's not extended. So even then, still very high exemption. So if your estate's following under these exemptions, there is no estate tax. Beneficiaries also don't pay inheritance tax. That doesn't exist. There is no tax called inheritance tax. So the only times that we're looking at, tax in an estate administration process is either estate tax because the value of the estate is so high, or income tax. So income tax is something that we can't really get rid of, whether we're an individual or an estate. So if, let's say that it takes a year to settle the estate, if within that time frame, the assets generated income while the estate was the owner or the trust was the owner, that income does still need to be reported, just like it would if it was in your name. There is an annual gift exclusion, and that is $19,000 per person for 2025. What that means is that when people gift less than that annual exemption, so that's a per person exemption, they don't need to report that. And so the IRS doesn't even know about those gifts. And it's only if you would gift more than 19,000 per person that you have to start reporting it. Now that reporting it doesn't mean paying taxes. It just means you have to let the IRS know that you made that gift. So let's say you made a $25,000 gift to a child. You would report that to the IRS. They would then keep a record of that gift. And when you pass, they look at the combination of how much you gifted during your lifetime plus your estate value to then determine whether your estate owes any taxes. Marital property agreements can be another component of estate plan, obviously only if you're married. But in that situation, what we often are doing is looking at, okay, do you want just traditional Wisconsin marital property law to apply to your estate? Or do you want to reclassify certain assets? And that would be the case in, for example, a blended family. Let's say you want to plan for some of your assets to go to your spouse, some of your assets to go to your children from a previous relationship. That's where the marital property agreement becomes an important component to just kind of solidify the classification of assets and the agreements that you and your spouse have regarding how your estate is distributed. Now we're getting into lifetime documents, so powers of attorney. And the financial power of attorney is often called a durable power of attorney. So some big benefit here is that it avoids guardianship. And a lot of times people think that their spouse automatically has the right to make decisions for them, and that is not the case. So your spouse only has the power to make decisions for you, whether that's financial decisions or healthcare decisions, if you've appointed them as your power of attorney agent. Without these documents, that's where the court, would need to appoint a guardian. So it's very important to have powers of attorney in place for everyone once they turn 18. The durable power of attorney, it's often called either durable or springing. And what that means is, when is it activated? So springing means there needs to be some sort of certificate of incapacity or a doctor's note describing the incapacity. Durable means that it would be effective immediately and doesn't need any type of doctor verification that the agent has authority to act. So that's just and I have clients that do it one way or another, just really is a matter of personal preference and just, kind of comfort level with who you're appointing and when would they be able to step in. This document is provided there is a state form that the state of Wisconsin has created for financial power of attorney, which is better than nothing. But I would say in terms of like a better planning tool would be to consider what types of powers your agent may need and then create a more comprehensive document. So when I meet with clients, we're talking about, okay, if your agent is handling your finances for you, you might at that point need some advanced planning like long-term care planning. And with long-term care planning, that often involves gifting or creating special needs trust or just a variety of different financial tools that you need to specifically authorize your agent to do, or otherwise they wouldn't have that authority. So I'm often drafting the durable power of attorney for my clients rather than having them use the state form. Power of attorney for healthcare, again, avoids guardianship. Usually this one is set up to be springing, which means that it requires a certificate of incapacity signed by 2 doctors before the agent would be able to start making decisions. The state form for the healthcare power of attorney is completely sufficient. That's very similar to the form that I use. So that state form or the forms that a lot of hospitals will provide, I think they all do a great job to cover all the bases. Some things to note, though, is that there are usually questions that you have to answer. And the questions are about, do you grant authority for your agent to make certain decisions? And those decisions are usually related to admission to a long-term care facility and like removing feeding tubes, removing life-sustaining measures. So you have to be very careful and read those questions thoroughly, make sure you understand them, because when you're checking yes, you're usually saying, yes, I give my agent that authority. If you check no, that usually, depending upon the way the question is worded, usually means no, my agent does not have that authority. And if you've checked no, then your agent doesn't have that authority. So then they can't admit you for long-term care. They would need to get guardianship and protective placement orders in that situation. So I typically suggest not checking no. And then just depending upon different end of life decisions, if you've checked no, they can't remove a feeding tube, then that is a hard no. They can't do that without a court order. So just really make sure you know what you're checking and make sure it's matches your wishes. A HIPAA waiver is a very important medical document as well, because the healthcare power of attorney only comes into effect when two doctors sign that certificate of incapacity. Before that point, the agent has no authority, even no authority to receive information. So I call the HIPAA waiver the in case of emergency document. If you're taken to the hospital and your family needs to know what's going on, what room are you in, what's happening, what treatment are you getting, they should have this authorization through a HIPAA waiver that could be applicable in any setting, right? Any hospital setting, any doctor's office, just a blanket HIPAA waiver is what I include in my estate plans. So now coming back to title and beneficiary designations, because at the beginning we talked about how, that's typically one thing that we start looking at when we're administering a estate. When we do estate planning, we have all the documents drafted and they're all signed. This is the next important step, is to make sure that the title and the beneficiary designations are in conjunction with your estate plan, that they don't conflict with your estate plan. So because the title and beneficiary designations supersede wills and trusts, it's very important that we make sure that everything is saying the same thing. So when we're using a trust, we can either title assets in the name of the trust, or we can name the trust as beneficiary, but we want to make sure that we've done one or the other. So we have to make sure somehow that trust is named on these assets. If it's not, then we still have the potential for probate because we haven't gotten the assets into the trust. So we're looking at, real estate that can happen through a deed, and then also beneficiary designations for life insurance, retirement assets. We're looking at the title of bank accounts and making sure that everything is, kind of flowing nicely into the trust. And then I'll turn it over to our question segment.
Fantastic. Thanks so much. This has been really great. We do have 2 questions. If you do have a question still, please put it in the questions. But right now we've got 2 that are sitting here. The first one is for Chris. And Liz says, I'm currently on my partner's insurance plan and he's leaving his job on December 18th, starting a new job on January 27th. We will be enrolling in a new plan through his new job, but our current coverage will end on December 31st. We're planning to do COBRA for the month of January, but I'm wondering if ending COBRA voluntarily before the 18-month max is considered a qualifying event for enrolling in a new plan, or if we need to wait until then for open enrollment, or wait until open enrollment.
Okay. So the the short answer is you don't need to wait. So when at the new employer, the initial eligibility, when someone first becomes eligible for coverage, and there's probably there may be a waiting period. So if the first day of full-time employment is Jan 27, the individual might have access to that plan on February 1st or maybe March 1st, possibly even April 1st. Typically, the latest we would see is first of the month following 60 days of employment. Often it is first following 30. Sometimes it's first following date of hire. And so whatever date that is, the new employee and their partner, their any dependents, would be able to go straight on that plan. And whether they've had COBRA for 1 month, 2 months, however long that is, that is that supersedes anything that has to do with the 18 months or the marketplace open enrollment rules.
Great, thank you so much. I appreciate that. Looks like this one's from Megan. Does probate apply if beneficiaries are listed?
It depends. So what I see often is that some assets have beneficiaries listed. Those assets pass without probate. So, that's a contract between you and the company. They have to pay the beneficiaries after you pass. So that avoids probate. But I think one thing to consider is that if you haven't addressed every single asset that you own, then we could still have a probate. So what I often see is that people are really good about naming beneficiaries on life insurance, retirement accounts, sometimes even bank accounts. Sometimes people have, added that POD designation to bank accounts, but then they don't think about real estate, or there's this one asset, one account that doesn't have a beneficiary named. So that's where we might have a combination approach of some assets passing without probate, some assets still going through probate. And then I guess I just want to also clarify, naming beneficiaries in a will does not avoid probate. So when I'm talking about naming beneficiaries avoiding probate, that's specifically on those beneficiary designation forms that you get from the bank or financial institution.
Right. Thank you. And then the next one is also for you. What is the difference between a will and a pour-over will? It was listed on one of the slides. And what is your opinion of the pour-over method compared to the will or revocable trust?
Yes, good question. So I didn't specify this, and the pour-over will relates specifically to the type of will we use when we use a trust. So when we use a trust, we have the revocable trust as the primary estate planning tool. That's where all the detail lies. So all the beneficiary information is going to be in that trust. But then we also have this document called a pour-over will, and it does two things. First, if you do have minor children, it nominates the guardians. So that's an important piece. And second is it says any assets not in your trust should transfer to your trust. And that's why we call it pour over, pour the assets into the trust. We hope that that's zero. We hope that there's nothing outside of your trust. But if there is, because something was missed and you didn't do the beneficiary designation or didn't retitle it into the trust, then that pour over will have the asset transfer into your trust to maintain consistency for your estate plan. So a pour over will and a trust go together as a package unit, and then the will by itself would simply be like a will naming who your beneficiaries are, and that would be handled by probate.
Great, thank you. And then somebody asked about when slides will be available. They will be available by Monday, my day tomorrow. I'm in a training all day tomorrow, so getting these onto our site is going to be tough. I will send copies of the slides to all who participated, and we will have the recording of this available on our YouTube after we run this through everybody's compliance folks that says, yes, we're good to go. So I'm going to go ahead and turn off our recording, which I